representing himself testifying against the bill?
Good evening, and a late evening it has become. Mr. Chairman, members of the committee, my name is John Rowland. I'm founder and president of the Constitution Society website at constitution.org, and was the Libertarian Party candidate for Texas Attorney General in the last 3 elections. I'm known as a legal historian. Technically, as per Mr. Gallego's explanation, I should really be shown as neutral because I am supporting the goal of this bill. I'm opposed to the language of it, and I propose a severe amendment which would essentially substitute better language, much better language, for most of the bill. As is briefly mentioned by the witness from the Attorney General's office, there are several unintended consequences that are likely to flow from the bill as drafted. First of all, having observed many federal judges over the years and magistrates, here's what they are set up to do. And so they are trained to do this. They're briefed on it. They have an organized pattern of doing it. If a federal agent is prosecuted by a state agent, the case is immediately removed to federal court. This is a very simple process. It is a 1-page filing. It is a notice to the state court and to the federal court, and it automatically removes. There's no consent on the part of any magistrate to the removal. It's automatic. I've done it myself in cases. All right? Having been removed to federal court, it only takes a phone call from the U.S. attorney to the judge or magistrate, and the odds are that it will be dismissed within less than an hour. And having observed the federal judges that serve in Texas, I haven't observed every one of them, but I'm willing to bet you're probably not going to find one that will not give expedited handling in such a case. Now, if the federal agent were to kill somebody while off duty, then they might be thrown under the bus. The original concept of official immunity was that the official had to act within his jurisdiction. By creep, a series of precedent and custom, policy, and practice of the federal courts in every circuit of the United States, this has evolved over time to considering an agent to be acting within his jurisdiction simply by being at work or on duty or under the direction of a supervisor. It is not necessary for it to actually be authorized by law. And what TSA agents are doing is really primarily following verbal orders. You probably won't find most of this stuff written, but verbal orders count too. All right, but it gets better. There's another potential consequence. There is a statute, 18 U.S.C. 111, according to which it is a federal crime to impede a federal officer, and any state or local officer who tried to enforce this statute, were adopted, could be charged with a federal felony, especially if he was carrying a weapon when he did it. Up to 30 years he was carrying a weapon while he did it. Now, it is probably not too likely that the feds are going to prosecute a state officer who tried to enforce this act. But they could. And if there's anything I've learned from observing federal officials and agents over the last couple of decades, if there is any language that they can seize upon in a statute or in a court precedent to abuse people, they will use it. These are not nice guys who are trying to get along. It's 20 years ago, yeah, maybe 10 years ago, but it has been getting worse and worse and worse over particularly the last decade. So you have an out-of-control federal government, and if you're going to take them on, you better know what you're doing, because this is a big challenge. We're talking about setting up another Fort Sumter here. You need to know what the potential risks are before you enact this kind of legislation. Now, at the end of the document that I've handed out to you here, I offer a substitute. It is a little complicated, at least so many people tell me, but it would work. How it would work in the TSA case, for example, is that a Federal Action Review Commission, a kind of grand jury, would be convened. It would hear testimony from complaining witnesses that this area of federal activity was unconstitutional. I would expect them to issue a finding that it is indeed unconstitutional, and that finding would trigger statewide resistance and non-compliance with the federal action. Now, what would this mean in the case of pat-downs and searches by screeners? Well, it would mean that whenever a passenger went to an airport at which the TSA was operating, he might see a sign or be handed out a flyer or otherwise be informed, maybe over a PA system. The Federal Action Review Commission has found that the TSA screeners are acting without constitutional authority. You're all urged not to comply with their directions to search you obtrusively. Now you've got every passenger on notice. There's no way that these TSA agents are going to be able to pick anybody out for special attention when every passenger is informed of his rights and works together in concert to resist it. This kind of massive public disobedience, civil disobedience, is the way to solve the problem. They would have to back down. There wouldn't be any arrests. There wouldn't be any prosecutions or removals, but it would work. And other such methods would also work for other kinds of usurpations. Every year, Congress passes 80,000 pages of legislation, which contain, by my estimate and those of many others, approximately 20,000 judiciable provisions that are unconstitutional. There is no way that a state legislature, especially one that only meets 140 days every 2 years, is going to be able to deal with every one of those usurpations one at a time in legislation.
And Mr. Rillo, let me say that it's not our intent to do that. We just want to deal with one at a time.
Yes.
Which would be the one in Mr. Simpson's bill. So if you could limit your comments to the one that Mr. Simpson is trying to address, because that is really the only, topic before the committee.
Yeah, and what I'm saying is that if this bill were only applied to state, local, or private agents, fine. But that's not what TSA agents are. As soon as you try to apply it to TSA agents, you're gonna be starting a meat grinder. One that is not gonna work out the way you expect or hope, or that I would hope. We need a different approach. And that different approach that I'm proposing, you would get the entire state mobilized to resist usurpations of this kind. That would work. So, I conclude at this point, if you have any questions. I'm a legal historian, so I actually have the answers that the guy from the Assistant Attorney General was unsure about. Because I've watched this through history.
Any questions? Mr. Rowland, we appreciate your testimony, and I will tell you that you put a lot of time and effort into this document, and so, thank you for that. You've obviously thought about this a lot.
I try, yes. That's what I do all the time.